Hello everyone. This presentation will focus on the performance of contract. When the parties to the contract fulfill their obligation arising under the contract within the time specified and in the manner prescribed, it amounts to performance of a contract. Under Section 37 of the Contract Act, a contract has to be performed by the parties to the contract, or an offer has to be made by the party to perform their respective promises unless such performance is dispensed with or excused. When the promisor makes an offer to perform his obligation under the contract to the promisee and the offer is not accepted, it is called tender. Here, the promisor will not be responsible for non-performance and will not lose his right under the contract. In order to be a valid tender, the tender of performance has to be unconditional and must be for his whole obligation. It has to be made by a person who is willing and is capable of performing the promise. Tender must be made at the proper time and place and to promisee or his agent. Where the contract is concerning goods, a reasonable opportunity to inspect the goods has to be provided. When the contract involves several joint promisees, tender can be made to any one of them. Tender may be tender of goods or tender of money. When the seller in the contract for sale of goods satisfies all the requirements of the contract regarding delivery of goods, but the buyer refuses to accept the goods, the seller can maintain as well as defend an action for breach of contract. In the case of tender of money, when the debtor makes an offer to tender money but the creditor refuses to accept it, the debtor will not be discharged of debt, but when the creditor sues the debtor for payment of debt, the debtor can set up the defense of tender. Creditor will get the amount due to him without interest and the debtor will be awarded costs for his defense. When a party to a contract refuses to perform his promise fully, the promisee can terminate the contract. But where the promisee indicates by words or conduct his agreement to continue the contract, he cannot put an end to it. When the promisee rescinds the contract, he is deemed to have rescinded a voidable contract. Here, he has to restore to the other party the benefits obtained by him under the contract. The Contract Act provides for situations wherein a contract need not be performed. When the performance of a contract becomes impossible or where parties agreed to substitute a new contract for the old one or to rescind or alter it, the contract need not be performed. Where the promisee dispenses or remits wholly or in part the performance of the promise made to him by the promisor, the promise need not be performed. When the promisee grants extension of time for performance or accepts any satisfaction for it, the promise need not be performed. When the contract is voidable at the option of one party and that party rescinds the contract need not be performed. Where the promisee does not provide reasonable facilities to the promisor for performance of his promise, the contract need not be performed. By whom should the contract be performed? The promisor himself has to perform the contract if that was the intention of the parties. These are usually contracts involving personal skills of the promisor or personal confidence of the parties. Where there is no personal consideration, an agent of the promisor can perform the contract. A legal representative of the promisor has to perform the contract when the promisor dies and the contract is not found on personal consideration. Where the contract involves joint promisors, any one of them may be compelled to perform the contract. Now, who can demand the performance? It is only the promisee who can demand performance, and if he dies, his legal representatives can demand performance. When there are joint promisors, that is, promise is made by two or more persons, all of them must jointly perform the promise unless the contrary intent appears from the contract. When there are joint promisees, that is, promise is made to several persons, the right to claim performance is available to all of them unless the contrary appears from the contract. Time and place of performance are matters decided by an agreement between the parties. Rules in this regard are contained in sections 46 to 50 of the Contract Act. Where in a contract no application has to be made by the promisee for performance and no time is specified, the promise has to be performed within reasonable time. When time is specified but no application is required, the promise can be performed at any time during the business hours on such day and at such place as specified. Where time and place are specified and application by promisee is required, the promisee is duty bound to apply for performance at a proper place within usual business hours. Where the promise has to be performed without application by the promisee and no place of performance is fixed for performance, the promisor has to apply to the promisee to fix a reasonable place for performance of the promise and perform it at such place. The promise has to be performed in the manner in which and the time at which it is required to be performed by the promisee. When the promises are reciprocal, that is, promises which form the consideration for one another, there are certain rules regulating their performance. When the reciprocal promises have to be performed simultaneously, the promisor is not bound to perform his promise unless the promisee is willing and prepared to perform his promise. When the order in which the promises have to be performed is fixed by the contract, it has to be followed. When the nature of the promises is such that one cannot be performed unless the other party performs his promise first, and when the latter fails to perform, he cannot claim performance from the other. For example, where A, a builder, promises to construct a house when B hands over the plot, clearing the debris accumulated on it. B cannot claim the performance of A's promise unless he hands over the plot, clearing the debris on it. When a party does not perform his obligation within the time specified, can the other party rescind the contract? It can do so only when time is the essence of contract, otherwise it cannot. Time is said to be the essence of the contract when it is essential for the party to perform its promise within the specified period in order to entitle him to enforce performance from the other party. Just because the contract contains a term specifying time within which the promise has to be performed, it cannot be said that time is the essence of such contract. When the contract contains clauses for extension of time or for payment of penalty for delay, time is not considered as essence to the contract. In commercial contracts, when time is specified, time is usually the essence of the contract. In other cases, the presumption is that it is not the essence of the contract. Time can be made essence of contract by giving notice subsequently. Whether time prescribed in the notice is or is not the essence of the contract is a question of fact to be decided on case-to-case basis. Coming to appropriation of payments, when a debtor owes several debts to one person and makes payment which is not sufficient to clear all of them, the debtor can decide to which debt the payment has to be appropriated. When he does not expressly indicate to which debt or debts the payment has to be appropriated, the creditor can apply the payment to any debt at any time. When part payment is made, it should first be applied to the interest, and when the interest is fully paid, to the principal, unless there is any contract to the contrary. Where the parties have a current account between them, the appropriation should be in the order in which the receipts and payments take place. The sum first paid in is the first to be drawn out. The first item on the debit side of the account is discharged or reduced by the first item on the credit side. To put it in a simple way, the items on the credit side of an account must be appropriated against the items on the debit side in the order of date. This is the rule laid down in Clayton's case. When the debtor does not intimate and the creditor fails to appropriate, The payment shall be applied in discharge of debts in chronological order, that is, in order of time. Can contracts be assigned? That is, can the rights and liabilities under a contract be transferred to a third party? It can be done under certain circumstances by the act of the parties or by operation of law. The assignment by the act of parties are governed by certain rules according to which contracts involving personal skill, ability, or other personal qualification cannot be assigned. A person making a promise cannot assign his liabilities or obligation under a contract. Rights and benefits under a contract can be assigned if the obligation under the contract are not of personal nature. An actionable claim can be assigned by an instrument or document in writing, and notice of such assignment has to be given to the debtor. For example, where A owes rupees 5,000 to B and C owes rupees 5,000 to A, he can assign the debt owed to him by C for payment of his debt to B. Assignment by law takes place upon the death or insolvency of a party. When a party to a contract dies, his rights and liabilities under the contract devolves upon his heirs and legal representatives. This does not happen in contracts involving exercising personal skill or rendering personal services. When a party becomes insolvent, his rights and liabilities incurred prior to adjudication pass to official receiver or assignee. This, in brief, is about the performance of a contract. Thank you.